Eugene, you're in violation of your contract.
Rules. Here's a rule for you. People can't eat stained glass parcels. I'll show you, automated.
Mr. Blandy, code red, free thinker.
Hello, good morning, everyone, and welcome to our presentation on quasi-contractual remedies.
My name is Jordan Nelson, and I'm from Group 6, and we're dealing with quasi-contractual remedies. With me this evening, I have Mr. Joel Ross from Abiola Wang Innes and Associates, and he'll be sharing some knowledge on these remedies. So the question I have for you, Mr. Ross, have you ever encountered cases where setting off was used to balance obligations between two parties?
I have. In practicing Guyana, the most common example I can think of is in divorce proceedings between husband and wife. Usually what happens is the court makes a declaration regarding the entitlement of the parties to their matrimonial assets. And so the court may say the parties are equally entitled to all matrimonial assets. Now what tends to happen is, as is normal, people might take a loan to purchase a car or a property. And so what happens is when dividing those assets, say for example, the parties acquired a home together and they're equally entitled to that home. But there's a loan was used to purchase a home, and there's an outstanding balance of $10 million on that. The property is valued $20 million. The court would not say, because the parties are entitled equally to share in this one. If one party wishes to retain sole ownership of the home, the court would not say, all right, that person will pay the other party $10 million, which would represent their half share, notwithstanding the existing home. The court, what they would do is set off the value of the other party's half share in the loan, and the party who wishes to retain sole ownership would pay them the balance.
Now let's look at our second interview with Attorney Crawford. Can you describe a situation where a quasi-contractual remedy, such as restitution for unjust enrichment, was applied?
I had a client who, unfortunately, the neighbor bought some sand to fill his yard or fill his land, and the person who delivered the sand placed it on the wrong lot and spread it out. So my client was told that there was a mistake, and he basically took the position that wasn't his business, and he's not returning the sand, nor is he paying for the sand that he received. Needless to say, they end up in court. I advised him that he should pay and settle the matter. End up in court, and the court basically said that he had to pay restitution because he received, or he was unjustly enriched because his property was obviously increased by the filling of sand.
Next, have you encountered cases where setting off was used to balance obligations between two parties?
In law, sometimes you shouldn't trust your client. Sometimes your client will be lying to you. There was an accident between two people, and my client car got damaged, maybe $2 million, and his insurance I think gave him about $1 million. But he hid that fact from me. And nonetheless, I sued for the $2 million. And somewhere between, during the discovery stage, like someone at his insurance company, my client's insurance company, informed the defendant that they had paid $1 million to him. But he didn't disclose that to the court. So what the court did in his judgment, the court basically gave cost and did a set off of the $1 million. So in the end, he didn't receive $2 million from the defendant, but he just received $1 million because the insurance had given him money.
Finally, can you explain a situation where the court refused specific performance and opted for another remedy? How was this issue resolved?
The last one, specific performance. Sometimes the court may order monies, will give monies instead of completing or giving the equitable relief of forcing you to complete a contract. A scenario that I thought about is I had a client from overseas who had a agent here, and she bought the property for $1.5 million. And the agreement was signed, and she paid $1 million with $500,000 to be paid at the passing of transport. And the seller then changed their minds and said, listen, we're not going to sell anymore. We don't want to sell anymore. And they returned a check to the agent of my client. The agent did not tell the principal that he received the money and for us to cancel the agreement or finish the agreement. He kept it, cashed it, and he didn't say anything. And when we were about to do a trial, the opposing side produced the bank records that he signed the check, and he collected back $1 million. So what the court did, the court just basically forced us to pay monetary damages for wasting the court's time, wasting the defendant's time. And I think the judge wanted to jail the agent for my client. But that didn't happen. And so the remedy of rescission was ordered, and the contract came to an end.
Today, the questions we will answer are: what is a quasi-contract? What is unjust enrichment? What are the main types of quasi-contractual remedies? How does setting off intersect with quasi-contractual remedies? And what is specific performance? And when is it refused as a remedy? What is a quasi-contract? Lord Wright described quasi-contract as a legal principle that ensures remedies for cases of unjust enrichment. It is a judge-ordered contract. The case Bailey versus West illustrates.
In Bailey v. West, 1969, Bailey took care of a lame racehorse after West disclaimed responsibility. West had sold the horse, but the buyer refused it due to its injury. Bailey expected payment for his services, but West refused, saying he never asked for the horse to be cared for. The court sided with West, ruling no quasi-contract existed. Why? Because West never requested Bailey's services nor agreed to pay for them. The key takeaway: quasi-contractual liability needs a benefit conferred at the request of the party. So if you're looking after someone's horse, make sure you've got an agreement for it.
What is unjust enrichment? Unjust enrichment is a legal term used when one party is unfairly rewarded at the expense of another party, typically without compensation to that party or any justification under the law. For example, Party A accidentally transfers money into Party B's bank account, which was meant for Party C, and Party B refuses to return the money. The elements of unjust enrichment include: 1. A party must have received a benefit at the expense or detriment of another, and 2. The benefit is considered inequitable, meaning there isn't a legal justification for the enrichment. The types of quasi contractual remedies we will look at today are restitution, quantum merit, and quantum valubat.
Restitution. Restitution is a legal remedy designed to prevent and rectify unjust enrichment by mandating that the defendant return any benefits received from the plaintiff, restoring them to their status pre-contract. Types of restitution include monetary and non-monetary. Quantum merit. This remedy allows a party to claim a calculated, reasonable payment for services provided, whilst quantum valubat. This applies when goods are provided without a formal contract and the provider seeks reasonable compensation.
We'll be discussing the set-off remedies. A set-off remedy and a quasi-contractual remedy operate in distinct legal contexts, but occasionally these concepts intersect. A set-off remedy is a defense that allows a party to counterclaim a debt owed to them against a debt owed to another party in the action. For example, if Party A must pay Party B $500 in restitution, and Party B owes Party A $300, a set-off would allow Party A to pay only the net difference of $200. And there are three types of set-off. There's the contractual set-off, the equitable set-off, and the legal set-off.
Specific performance is a discretionary remedy offered where damages do not adequately compensate the claimant. It's an equitable remedy that allows for the court to order a defendant to perform his obligations as stated in the contract. Refusal of specific performance usually occurs in situations such as hardship to the defendant. The courts will refuse specific performance wherein it would cause great hardship or unfairness to the defendant, even though specific performance would have been best for the claimant.
Patel v. Ali, 1984, 1 All ER 978. A seller and her husband agreed to sell their house, but delays hit them hard when the husband went bankrupt. After signing, the seller faced massive personal challenges: cancer, losing a leg, and caring for 2 kids. The buyer wanted specific performance, basically forcing the sale, but the seller appealed, citing her hardships. Here's the twist: the court agreed. They ruled that severe hardship arising after the contract could justify refusing specific performance. Instead, they awarded damages. Why does this matter? It shows courts can prioritize fairness over strict contract enforcement. For law students, it's a key lesson in balancing legal principles with human realities. Remember, in law, context is everything, and sometimes life's hardships can change the game.
Contracts lack mutuality. Essentially, specific performance will not be enforced against the defendant if it could not have been enforced against the claimant. Contracts are vague as to the performance required. Contracts require constant supervision.
In 1893, Ryan v. Mutual Tontine Westminster Chambers Association shook up contract law. Ryan rented a service flat where the lease promised a porter would be constantly in attendance. Sounds straightforward, right? But here's the twist. Ryan found the porter wasn't always around, so Ryan took it to court, asking for specific performance, basically making sure the porter was always there. But the court said no can do. Why? Enforcing this would mean constant supervision, something the court just won't do. The takeaway: not all contract terms can be specifically enforced. The court said no can do. Why? Enforcing this would mean constant supervision, something the court just won't do. The takeaway: not all contract terms can be specifically enforced.
Contracts require personal services. The claimant acted unconscionably. The claimant had an undue delay in bringing his claim.